Hey guys, welcome back to my channel. My name is Thanh Võ, and if you don't know me, I've been doing YouTube and share a lot about EB3 visa process and information for the last 3 years or so. At the same time, if you've been following me, I've really been genuinely sharing about my life, what's going on here, what I do, where I travel, and on create an abundant life in the US. So technically, I did my startup around 2 years ago, and I know, if you don't know, I actually invested in my own startup for the last 2 years in 2022, and technically it took a lot of my time away from my family, my friends, and also my social life. I did not really go out there and connect with anyone because I was so busy to actually build a business, to invest in a startup in Vietnam, to actually help immigrants come here through the platform, and it was really challenging. And after my grandma passed away around August last year in 2023, I actually decided to take a break because I could not achieve and could not handle the stressful of the business anymore. So that's the reason why I decided to spend time with my mom, flew my mom here to US to make sure that she had someone with her after my grandma passed away, and she was able to actually visit me, and it was third time of me seeing her, and it was really a valuable time for me, and I decided to take a break to rejuvenate and actually find time for myself to reorganize the plan of the business, where I want to take it in place, and also actually raise the capital for next venture business, because I've been spending over $50K for that business and did not go anywhere. I've been rejected a lot of clients or say no because I don't want to offer services or something that I'm not really fully can offer the best quality for them, and that is just how I am. And right now in July 2024, I'm really confident. Right now I'm taking that time back, and also actually got back to the journey of networking, at the same time socialize with more people in the business world, at the same time the social, to balance my life, at the same time learn more to see what's out there beside what I am currently doing to raise the capital for the business. For that being said, I decided to go back to do networking professionally for business around February 2024, and I've been traveling a lot for travel shows, at the same time adding up all that value information and connections I make through different conferences, event, mastermind for the last only short, maybe February, March, April, May, June, around 5 months right now to gather all the resources. I'm really happy to actually found someone that can actually boost or help me to help you guys make your dream coming here to America be more effective, and at the same time safe, and also have some return on investment in your money in a better way compared to different type of visa. And on the way building well right now for investing in my retirement accounts, and at the same time for real estate, my personal, to raise the capital for my own business. And I'm glad to share with you guys the upcoming ventures that I'm going to partner with someone that can help you, or the company can help you to make your dream come true. For that being said, let's actually look into detail to learn more about the L1 visa that I've been sharing from the previous presentations if you haven't had a chance to look at it. And let's learn together to see what is the visa offer, how this type of visa actually can bring you to achieve your green card applications, how long will it take, and how much does it require in order for you to invest, and how can you do everything at the same time with this investment. And let's learn the first step about the definitions of the L1 visa from USCIS website. So I am on the USCIS website .gov, stand for U.S. Citizenships and Immigration Service. And you guys can see in here the L1 intra-company transferee, executive or manager. The definitions, the L1A non-immigrant classifications enable U.S. employers to transfer an executive or manager from one of its affiliated foreign office to one of its office in the United States. This classification also enables for a foreign company that does not yet have an affiliated U.S. office to send an executive or manager to the United States with the purpose of establishing one. The employer must file Form I-129 petitions for non-immigrant worker with fee on behalf of the employee. The following information describe some of the features and requirements of the L1 non-immigrant visa program. So this is the general qualifications of the employer and employee. To qualify for L1 classification in this category, the employer must first have a qualifying relationship for a foreign company, parent company, branch, subsidiary, or affiliate, collectively referred to as qualifying organizations, and second, it's currently be or will be doing business as an employer in the United States and in at least one other country directly or through a qualifying organization for the durations of the beneficiary stay in the United States as an L1. While the business must be viable, there is no requirement that we engage in international trade. Doing business means the regular, systematic, and continuous provisions of goods and services by a qualifying organizations and does not include the much presence of an agent or office of the qualifying organizations in the United States and abroad. To qualify, the name employee must also, the two key points here, generally have been working for a qualifying organization abroad for one continuous year within the 3 years immediately preceding his or her admissions to the United States and be seeking to enter the United States to provide service in an executive or managerial capacity for a branch of the same employer or one of its qualifying organizations. So executive capacity, which is like C-level and above, generally refer to employees' ability to make decisions of wide latitude without much oversight. You not give or receiving like instructions or guidance from a higher level because you are the one who actually in charge of the business. That's why the C-level about. People bring the work to you, hey boss, can you approve this? That's how the executive level about. Managerial capacity generally refer to the ability of the employee to supervise and control the work of the professional employee and to manage the organizations or department, subdivisions, functions, or component of the organizations. It may also refer to the employee ability to manage an essential functions of the organizations at a high level without direct supervisions of others. See sections 101A44 of the Immigration and Nationality Act as amended and 8 CFR 214.2 L1II for complete definitions. So for this, you need to have a new office. For foreign employers seeking to send an employee to United States as an executive or manager to establish a new office, the employer must also show that the employer has secured sufficient physical premises to house the new office, the employee has been employed as an executive or manager for one continuous year in the 3 years preceding the filing of the petitions, and the intended U.S. office will support an executive or managerial positions with 1 year of the approval of the petitions. So period of stay for this is the qualified employees, which is you guys from outside U.S., entering the U.S. to establish a new office will be allowed a maximum initial stay for 1 year. So you can stay here for 1 year as they mentioned. And all other qualified employees will be allowed a maximum initial stay of 3 years. For all L1 employees, requests and extensions of stay may be granted in increments of up to additional 2 years until the employee has reached the maximum limits of 7 years. So how about the family of L1 worker, which is you? You're the main applicants, and if you have family or you're single, so if you do have a family, this is for you. The transferring employee may be accompanied or followed by their spouse and unmarried children who are under 21 years of age. Just remember, under 21 children is really important, because if you're over 21, they will not able to tag along with you, and it will take a long time in order to actually do the paperwork. Spouses and children may seek admissions in the L1, L2 non-immigrant classifications, and if approved, generally will be granted the same period of stay as the employee. So if you stay for 1 year, they also can stay for 1 year. If you stay longer, they do the same thing. If these family members are already in the United States and seeking change of status to or extensions of stay in L2 classification, they may apply collectively with fee on a form of I-539, applicant to change or extend non-immigrant status. So there's different form if you're already currently inside the U.S. for change of status. So this is a little bit similar to another situations that I mentioned with AB3. Spouses of L1 workers invalid L2S non-immigrant status are considered employment authorizations incident to status. DHS issue evidence of such employment authorization that is acceptable for completions of Form I-9. Employment eligibility verifications include 1. An unexpired Form I-94 with annotations reflecting L2S non-immigrant status. As of January 30, 2022, USCIS and CPP began issuing Form I-94 with a new emissions code for spouses of L1 workers, L2S. An unexpired Form I-94 reflecting this new code is acceptable as evidence of employment authorizations for L spouses under List C of Form I-9. Second, an unexpired Form I-94 with annotations reflecting L2 non-immigrant status, together with a notice from USCIS regarding the new emission code. USCIS will send L spouses with a Form I-94 issued by USCIS before January 30, 2022 that was notated with L2 non-immigrant status, a notice regarding the new emission code that, together with an unexpired Form I-94 reflecting L2 non-immigration status, serve as evidence of employment authorization for such spouses under List C of Form I-9. For more information, you can check web alert on their USCIS website. Third is unexpired employment authorization documents. E stands for EAD, L spouses are not required to request employment authorizations by filling Form I-765. Applicants for employment authorizations may still file Form I-765 with fee in order to obtain an employment authorization document. EAD, Form I-766. EADs are acceptable evidence of both identity and employment authorization on the list of A or Form I-9, or 4 is a facially expired EAD with additional documentation to show EAD is ultimately extended as discussed below. It's actually a lot of information that we really not necessary to learn here because, you know, the attorney actually would do this for you. But if you want to learn more, you can go to the website and read the rest, because I think that's kind of like long. But hey, we are here, so let's continue doing that. Normally, DSS regulation provide an ultimately extension period of up to 180 days from the expiration date stay on the EAD. In May 2022, DSS published a temporary final rule creating a CFR 274-13D5. Temporary increased the ultimate extension period up to 540 days. The increased ultimate extensions period under a CFR 274-13D5 was available to eligible renewable applicants who had timely and properly filed EAD renewal applications pending during approximately 18-month period beginning May 4, 2022 and ending on October 26, 2023. Increased ultimately extension under May 2022 temporary final rule remain valid until their renewal application is approved or denied, or up to 540-day period expire counted from the expiration date of the employment authorizations or their EAD, or the end of the L2, L2S non-immigrant status, whichever earlier. Like I said, read the rest on the website because it's long. Also, Form I-129 pilot program for Canadian L1 non-immigrants. From April 30, 2018 to April 30, 2022, the California Service Center and the CPP Plan Washington Port of Entry, POE, are participants in a joint agency pilot program for Canadian citizens seeking L1 non-immigrants status under the North American Free Trade Agreement, NAFTA. For additional information, please visit the form and different thing. Blanket petitions. This is another thing. Certain organization may establish to require intra-company relationship in advance filling individual L1 petition by filling a blanket petitions. Eligibility for blanket L certification may be established if the petitioner of each of the qualifying organizations are engaged in commercial stays or services. The petitioner has an office in the United States that has been doing business for 1 year or more. The petitioner has 3 or more domestic or foreign branches, subsidiaries, and affiliates, and the petitioner, along with the other qualifying organization, meet one of the following criteria: have obtained at least 10 L1 approval during the previous 12-month period, have a U.S. subsidized or affiliates with combined annual sales of at least 25 million, or have a U.S. workforce at least 1,000 employees. The approval of blanket L petitions does not guarantee that employee will be granted L1A classifications. It does, however, provide the employer with the flexibility to transfer eligible employees to the United States quickly and with short notice without having to file an individual petition with USCIS. So, where an L1 visa required, So in most cases, once the blanket petition has been approved, the employer need only complete the Form I-129S, non-immigrants petitions based on the blanket L petitions, and send it to the employee along with a copy of the blanket petition's approval notice and other required evidence so that the employee may present it to a consular officer in connection with the applicants for L1 visa. Another one is Canadian with approval blanket petition seeking L1 classifications. So if you are a Canadian citizen who are exempt from the L1 visa requirement, may present the complete Form I-129S and supporting documentations to a U.S. Customs and Border Protections CBP officer at certain ports of entry on the United States, Canada land border, or at a United States pre-clearance pre-flight inspection station in Canada in connection with applications for admission to the U.S. in L1 visa or status. Optional filling with USCIS, that's another info in there, and also more information you actually can check in there with the filling mutable L1 intra-company transfer petitions or frequently asked questions, and also VIBE program and work authorizations. So that's a briefly info for the L1 visa for intra-company transferee, executive, or manager here on the USCIS website. So next, you're actually going to watch the seminar that the company I actually found it to share with you more details information for educational purposes, so you can understand about how they can help you to achieve the L1 visa, and then after that, how can they help you to do the rest of your process. So continue watching, and please do send or comment if you have any questions. At the same time, please contact me directly if you are qualified and thinking to apply for this visa in the future for this investment, and make sure that you are aware of these info. At the same time, find the right resources to learn more about this, and do not forget to subscribe to my channel. Let's actually click on the next video to learn more detail about the L1 visa, and let me know if you have any questions.